Hi, everyone, and welcome to On Trial, the podcast where we explore how to build your practice, trial tactics, and what can make and break your case. We're your hosts. I'm Matt Heimlich.
And I'm John Risvold.
And for this episode, I had the pleasure of talking with Kate Conway from Power & Rogers in Chicago about a really tremendous verdict that she won recently in Cook County, where she got $8 million for the family of a woman who unfortunately and tragically contracted a MRSA infection at a medical clinic and died a few weeks later as a result. You'll hear Kate go through it in detail, but John, what was your impression after taking a listen to the interview?
There's so much. The thing that I'm the most impressed with is how Kate just sort of makes, for us in the interview and probably for the jury as well, very complicated medicine, very understandable. And she's a good teacher. And I think, and I'm sure you know, you do a lot of medical malpractice work. When you're dealing with something complicated like medicine, even if it sounds simple, like a MRSA infection that's misdiagnosed, even if it sounds simple or looks simple on paper, you still have to be able to teach it in a way that is not condescending and in a way that is bringing the jury to your side of the argument. And, you know, the way she describes the case throughout the interview and the way she describes how her and her partner Larry Rogers Jr., how they worked with experts or against experts or used particular disclosures or whatever it might be to educate the jury in a very non-condescending, kind way, I think really helped them win over the jury. And it's a difficult thing to do because the medicine is so complicated.
Yeah, all of that really comes through. I mean, she's so articulate and she makes it so clear and so simple. It's really an amazing thing. One of the things I did want to point out that I found really interesting about how they tried this case is that the division of labor, I guess, between her and Larry was, is going to do liability and then Larry's going to do damages. I thought that was a really interesting way to break up a case. You know, usually, I tried a case with somebody else and, we'll divide the witnesses, basically in half, just based on scheduling or based on area of expertise. You'll do the doctor, I'll do the nurse, that kind of thing. But I've never really divided it, liability and damages, and into the extent they even did that during closing, which I thought was very cool. And that it makes a lot of sense, but I've never done that before, never really thought about doing it. And I just thought it was a really interesting way to approach putting on a case.
Yeah, it's super interesting. I've seen it done in jury selection. I've seen, one attorney is going to handle discussions of liability, one's going to handle discussions of damages just in jury selection. And then it sort of gets chopped up the same way you've described. But I really like the idea, and she said it, and it makes perfect sense, sort of a light bulb went off. I like the idea of splitting the closing. That way, the jury's not listening to one person essentially lecture for an hour, hour and a half, maybe longer, depending on how complex it is and how much evidence is in. They get sort of a break and they get to hear from multiple people who have different styles or who had just, a change of pace a little bit. I'm sure that helps keep the jury engaged in a very complicated med mal. It's something that I'm going to keep in the back of my head moving forward with all of my cases, because I'm a big believer in trying cases in teams, not by yourself. And, this is a really good way to sort of turn the team model that you and I are talking about, where you just sort of chop it up on its head and make it more effective for a jury.
Yeah, there's a lot of good stuff in here from Kate. I mean, from the way that she, distills the medicine down to the way that they put on their evidence to, some of the techniques they use in jury selection to kind of, put their issues at the forefront. I mean, this is a great episode, great conversation. Today, we're going to be talking with Kathryn Conway. Kate is a partner at Power Rogers in Chicago, where she represents injured victims and their families in medical malpractice, auto accident, trucking negligence, and other personal injury cases. Kate has received numerous awards recognizing her skills and achievements, including being recognized as one of the top 50 women in law for 2021 by the Chicago Daily Law Bulletin. Kate has won numerous multi-million-dollar medical malpractice verdicts and settlements, and among them, the $8 million verdict we're going to be talking about today. Kate, thanks again for coming on.
Yeah, thanks for having me, Matt.
Yeah, why don't you tell me a little bit about your case and your client? Give us kind of an overview of the whole situation that led to the trial.
Sure. So this case related to an outpatient visit that occurred back in 2015. Our client was a 59-year-old woman who ultimately passed away, and we were first approached by her husband. The case was set to go to trial originally in April 2020, 2 weeks after the shutdown occurred. So COVID-related shutdown, I mean. So I had been fully prepared, ready to go forward, had to break the news to my client, and he subsequently passed away. So her spouse died during the COVID-related shutdown. And by the time the case was our clients had become her 3 adult children. But in terms of the underlying facts of the case, it related to an outpatient visit at an advocate facility. Basically, our client comes in. She's complaining of fever, chills, and chest congestion. And the physician assistant who saw her elicits that she has a cough that's productive, but she had a temperature that was 99.9. So they were arguing that she didn't have a fever. She had a normal respiratory rate and a normal oxygen saturation level, but she had a slightly elevated heart rate. And most importantly, and what we tried to make the case about almost exclusively, was she mentioned to the physician assistant, and this was recorded in the PA's note, that she'd spent time with her father in a nursing home who'd recently tested positive for MRSA. So she's ultimately seen for what we were contending was a very short visit. It hadn't come up during discovery, but at trial, we brought out that the visit with this PA lasted more or less 8 minutes. And then she was sent home with a Z-Pack and instruction to follow up in a couple of days if she was worse. 2 days later, she presents to the emergency room at Advocate South Suburban. And at that point, and everyone agreed about this, she was very ill. She had advanced pneumonia, which eventually they confirmed to be MRSA pneumonia. And most importantly, again, what we tried to make the case about was that Z-Pack, it is an antibiotic, and it's a broad spectrum antibiotic, but it does not cover MRSA. So we allege that our client was discharged after expressing concerns about a MRSA exposure with a drug that didn't treat MRSA.
So you talked a little bit earlier about how you're all ready to go to trial before the pandemic kind of shut everything down. Talk about the kind of things that you did to get the case ready for trial. Did you do focus groups? Did you get consultants involved? What was that process like?
Yeah, great question. We didn't focus it. I've only done a couple focus groups in my career, and we've done them on really just gigantic or very complex cases involving numerous defendants where we were trying to strategically decide, some really important either kind of order of proof cases or, trying to compare liability amongst the multiple tortfeasors. In this case, really, I just used my immediate resources. I talked to all of my colleagues and kind of got their input on the case, especially once I had additional time because of the shutdown. I did a bunch of research on other cases that Dave Hall had tried, that Advocate had tried, other cases involving failure to diagnose or infection cases. And I tried to just look at what approach the defense might take, what approach has been successful for others, and then just kind of refined the approach I was going to take and all of the demonstratives and the other evidence I was intending to use at trial. So I did kind of a lot of informal preparation in that regard. But yeah, I didn't call in a consultant or anything like that for this one.
Yeah, although it sounds like you tried to make the case simple, that there are clearly a lot of factors at play, especially in a failure to diagnose type case. What kind of techniques do you use to present your case to the jury to make these complex medical decision-making issues more understandable?
Yeah, that's a really good question. And I think that really is the biggest task that we as plaintiffs lawyers kind of face, especially in a med mal context. But what I tried to do was boil the case down to a couple of things. And one of those things was obviously MRSA. And I just felt like the defense could never run away from the fact that the Z-Pack didn't treat MRSA. So I was trying to use the medical record against them, even though they were trying to use the medical record in their defense. So I fronted almost everything I knew they were going to present as, here's her normal respiratory rate. I acknowledged that in opening. Here's her normal O2 saturation. I acknowledged that in opening. But I kind of built up with some of these, other facts to the one inescapable thing in the record that she mentioned MRSA and she was sent home on an antibiotic that was not capable of treating MRSA. And I tried to really emphasize that by talking about MRSA and what that word means, MRSA, right? The R is for resistant. It's resistant to certain antibiotics, and this is one of those antibiotics. And then another kind of interesting thing that played out differently at trial than I had anticipated was that our client was diagnosed with an upper respiratory infection. So she wasn't diagnosed with the flu, and she wasn't diagnosed with anything more specific than that. And she certainly had some signs and symptoms of an upper respiratory infection. But I was trying to highlight all of the things that were indicative of the flu and a lower respiratory infection. So I was literally making these gestures of like the neck up anytime I would talk about upper, and then, the neck, chest down when I would talk about lower respiratory. And I think that was compelling. I just tried to make it make as much sense as possible. Like, this is logical. Upper respiratory impacts this system, the upper respiratory system. Lower impacts this system. And so I had a bunch of demonstratives that were much more involved, but I was literally pointing to them repeatedly just for the direction of up and down. And I think that ended up, being very compelling to the jury, that they didn't necessarily have to get into the weeds. And the defense, kept trying to drag us there, but they didn't have to get into the weeds in looking at this case. They could simply look at the medical record, and they could rely on their common sense. And I repeated that throughout opening, throughout a lot of our exams, and in closing argument as well.
I think that's really interesting that you went that route with it. There's so many different ways to present the evidence, and it's a lot of people rely on these very expensive animations and all these other things, and it turns out like sometimes the simplest idea is the best. It's just gesturing repeatedly to make your point clear. I mean, that's really interesting to hear. And it sounds like, obviously it worked in your case, which is terrific. So let's talk about jury selection in this case. I know that trials are ongoing. I know yours was one of the I assume one of the ones that was ready to go immediately before the shutdown, one of the first ones to go as courts have slowly but reopened in Cook County. What was your approach to selecting a jury for this case, and how did that play out?
Yeah, that's a great question. So we actually, Larry Rogers Jr. and I picked two juries in this case, because we picked one and then we had a COVID-related mistrial. One of the courtroom staff came down with COVID. We had to declare a mistrial, and then 5 days later repick our jury. So, we definitely focused a lot on damages. We knew and non-economic damages in particular, right? We had some economic damages. We had medical bills from the time that she was at South Suburban through her death, which was 11 days, and almost $250,000. And Larry beautifully, kind of off the cuff, said something like, this case, you're going to hear about economic and non-economic damages, and you're going to hear testimony about the medical bills, that for 11 days, they were $250,000. And that's just for 11 days. But that a death then occurred, and, you're going to hear testimony that our client could have lived another 20, 25 years had she not succumbed to this illness. And so if $250,000 is the value of 11 days, what's the rest of her lifetime? He did something like that was just so well done. And so all of a sudden you have all these jurors, nodding along, and it really made it a lot easier, I think, to ask them questions about non-economic damages. So we did a lot of that. If they had any kind of preconceived notion of an inability to award many millions of dollars, for a loss of love and companionship. We went through a lot of that. We knew that was going to be important. We were also really concerned because the surviving spouse had died. And so we fronted the fact that his claim survives his death. And we're still pursuing that here. And does anyone have a problem with that? So we kind of fronted that in voir dire. And then we spent some time going through, does anyone have experience with upper respiratory infections, the common cold? And of course, everybody did. Has anyone here had the flu? Yeah. And we were kind of suggesting that the flu is very different than an upper respiratory infection than the cold, and getting a lot of acknowledgement from the jury about that, which I thought was, again, kind of a hopeful setting of the table by the time we actually got to trial. And then we even asked people about, MRSA, and a fair amount of them had heard of it and knew really only one thing, or two things. One, that it was highly contagious, and two, that it's resistant. I think a couple of people said, I know it, not everything treats it. Not every antibiotic treats it. So I loved that came out before I even had to say it in opening. Yeah. So that was kind of our approach.
That's really interesting. I mean, I think it's always difficult to try to flesh out the utility of wrongful death damages. You always get someone who says, well, they're gone now. What can really we do to help? And it sounds like you and Larry really did a nice job of addressing that before you put on any of the evidence. And then
I don't know, Matt, have you ever used a questionnaire when you've done voir dire in these cases?
Yeah, I've used the ABOTA questionnaire. Sometimes the judges make you modify it a little bit here and there, but I've used that template a couple times.
Yeah, that's what we ended up doing here. I made some modifications to apply to the facts of our case. Our judge was actually a little resistant to it just because she thought it wasted, or I shouldn't say wasted. It took additional time that she wasn't sure was necessary, but ultimately defense counsel agreed. We made a few modifications at their request and we used that. And I thought that was really, really helpful to being able to ask some targeted questions in follow-up during voir dire. I really like the questionnaires. I don't know.
Oh, I do too. I think it gives us help because in other jurisdictions, you get a lot more information about who your veneer might be. And in Cook County, you kind of just show up and have to go with it. So I think having, at least something written down on a piece of paper, that you can look at and at least take a couple minutes to get a quick sense of who this person is and what kind of experiences and beliefs. I'm a huge proponent of it. And I hope more judges start coming around to it because I really think it's very useful for both sides.
I agree. That was really kind of my pitch was, look, there's no advantage to us. There's an advantage to everyone. So, but ultimately we agreed. And because we were in agreement, the judge was fine with it. But I just tend to think that people are a little more candid when they don't have to suddenly speak up, right, in a crowded courtroom. And also, it's kind of hard to answer a question when you're immediately presented with it without having a little time or opportunity to think about it. So I like the questionnaire because it gives jurors both of those opportunities, right? They can be a little more candid because they're not being called and they have some time to actually think about and then write down a response. So
right. People generally don't like public speaking. That's usually not, totally. Especially when you're packing all these people into a jury box and you're trying to get them to express, some of their closely held beliefs. And it's nice to give them kind of a primer or a warm up so they get a sense of, what it is we're talking about. And, ultimately then you especially the plaintiff's attorney, get to go first. You can kind of go into why we're talking about, these beliefs because it may impact, their ability to, be a juror on the case and view the evidence, through a neutral lens as opposed to coming at it with some sort of bias one way or the other. So then moving on to opening, how are you trying to tell the story of your case, like you said, while, also addressing the anticipated defenses? Being a plaintiff's attorney, the big advantage, especially in closing, is you get rebuttal, not so much in opening. So you kind of have to front all that. Tell us about how that worked out.
Yeah. So I basically started with what I thought was a little bit of kind of a punchy, kind of attention grabbing, short statement that, this case is about a MRSA infection, and I just wanted to set the stage right there. That's what it's about. It's not about all these other things the defense is going to talk about. That's what it's about. And then in closing argument, I kind of reiterated that, like, I told you that's what this case was about. That's what this case is about. It's really quite simple. And then I went into, a few things, right? I gave them a quick recitation of kind of the main points or the main facts, but then I took a step back. I went through, burden of proof, thanking them for their service. And then it's something that we always like to do, especially in a case like this, is talk about, when we're talking about burden of proof, that the injured party, the plaintiff, is the one who bears the burden. But interestingly, the injured party doesn't have the opportunity to make any recordations in their medical record. They, and when they pass away as a result of the care, they don't even have the opportunity to come into court and to tell you about their memory of the events, their memory of what happened. And I like couching that in the burden of proof explanation, because I like then going on to, but despite that, despite the fact that we have the burden, despite the fact that we have to, at least in part, rely on the medical records, in this case, the medical records are going to prove that there was negligence in the care, that there were errors made. And, just kind of putting it forward in that way, I think is like a nice lens for the jury to perceive the evidence and how it comes through. So I always make an effort to do that. And then I went back and I got into the real, details of the case, and I pulled up medical records. I walked them through everything. I kind of subtly tried to anticipate and front a lot of the things I thought defense was going to talk about in their opening. And I used a lot of demonstratives and preface that, you're going to hear testimony about this. You're going to hear it from these witnesses. They're going to tell you and explain this. So I was explaining something that became really important in our case, the connection between flu and MRSA, or really any bacterial infection, but that flu in particular, the flu virus predisposes us to bacterial infection. It's a big risk factor, unlike the common cold, for development of a lower respiratory infection. And that's not something that you or I might know, but that's something that urgent care clinicians like this physician assistant is trained to and does and addresses all the time. And so I had kind of a demonstrative about why that is and spent a lot of time on that, because one of the main allegations was there was never a diagnosis of the flu. In other words, she didn't even get that right. There was never a diagnosis of pneumonia, and there was never a referral to figure out if there was a pneumonia. But most of all, no antibiotic was given that could treat MRSA. And so I kind of ended on that simple note, reminding them of these omissions. And that's really how I approached it. Yeah.
I love that, particularly about, having to prove your case with their records that they have complete control over and your client has no input on. I think it's one of the absurdities that we have to deal with, but I really think that that's a great way to approach it and, get it out there. So it gives them, like you said, context to the information they're being presented with.
Yeah.
So, we talked a little bit about explaining the medicine in a way that was understandable to the jury. Can you go through some of the highlights of the testimony that you put on to kind of hammer home, what your case is about and, connecting all the dots between, the failure to diagnose and prescribe the right medicine and what ultimately happened to your client?
Yeah. So, I didn't want to get too into the weeds with debating signs and symptoms, because again, there's some overlap between upper respiratory, common cold, and the flu. But there are three kind of distinct things about the flu, which are fever, chills, body aches, and cough. I was kind of including fever and chills as one. So fever, chills, body aches, and cough. And she complained of all of those. And so I originally had drawn up a signs and symptoms board. And then I was like, I don't like this. I think, as we got closer, I think this is just giving them too much credit to create some confusion among the symptomology. I don't want to go there. So what I ended up doing instead was on the direct exam of our standard of care expert and on the direct exam of our causation infectious disease expert, I just had a flip chart, old school flip chart, which I've never done before because I'm usually someone who has, pre-made, pretty demonstrative. So instead, I did this and I was doing it in an effort to, one, not get, I thought there was less chance defense was then going to take that and try and create confusion amongst that demonstrative. But two, I was hoping if I wrote down these things and they saw me writing it out, that the jury would follow me and write out these things as well. And since there were really only 3 symptoms of flu I was going to write down, and there were only 3 symptoms of a lower respiratory or a pneumonia that I was going to write down, I figured that was clean enough to kind of do on the spot. And I think that ended up working pretty well, because what I ended up doing on direct exam to explain the difference between cold and flu was really focus on those 3 distinct things for flu. And so I wrote it down just kind of toward the beginning of their exams when I was asking them about, is this a virus? Is this a bacteria? What are the typical signs and symptoms of this? And then when we got to talking about our patient and the deviations, I had them explain, what signs and symptoms were present in our client on this date when she was seen by the PA. And I went back to the note highlighting exactly where those things came from. And then I walked over to that list I had made and I drew a little check mark next to each so that the jury could see, hey, look, everything they just told me about is right there. And I thought that was a little better than side-by-side comparisons of, these different conditions where, again, you would see some overlap and maybe that would cause you to give, some benefit of the doubt maybe to the practitioners. So that was one approach that I had in trying to explain kind of these overlapping viral and bacterial infections. And then the other thing was this connection between flu and MRSA. And so I had a demonstrative I think I mentioned the one of the upper versus the lower respiratory system. And I had, again, really just kind of used that to repeatedly say, and those symptoms are all up here. Okay, yeah, those symptoms are all down here. But then I had another one where it took that same anatomical drawing and it took a call out of kind of the upper airway. And it showed the lining of the upper airway. And our upper airways, as I learned in this case, are lined with this stuff called cilia. And cilia is this mechanism that our body has in the lining of the upper airways to push out and to resist bacteria. You know, the lungs are generally thought to be sterile. You know, our mouths and our upper airway are not. So the cilia protects our lungs from infection. But the influenza virus specifically targets and knocks out, wipes out in a way that other things like smoking and other illnesses do not, that cilia, and allows for an open pathway to infecting the lungs. So we made a big deal of that in conjunction with the timeline of the symptoms that our client reported having, and saying, look, the time that she's exposed to her father with MRSA is the exact time that she would have the ciliary dysfunction because of the flu. And that's why the flu was so important to diagnose on this date. That's an important distinction. You know, details matter in medicine. Upper respiratory infection isn't a risk factor for pneumonia the same way that the flu is. And so I use that demonstrative like a million times with almost every witness, because I just thought that had to be a real key. And the other reason I thought that had to be a real key is in our issues instruction, we were going to say failure to diagnose and failure to treat the flu. And again, looking at their medical record, influenza never, ever appeared in the medical record. So I felt like that was going to be a really strong point for us. So I just kind of kept going back to that and really making sure, and the jury did, because when I spoke with them afterwards, you know, they definitely understood that. And a couple of them said, next time I get the flu, I'm really going to think about the ciliary dysfunction. So yeah, that was kind of a key point medically.
Yeah, I had no idea. So you learn something new every day. That's you got to love these cases. And then what was the defense response to all this? You know, you had your case, you had your side of the story. What were they offering in defense of the clinic and the nurse practitioner?
So many things. So they certainly defended standard of care, but they even defended causation. And so, you know, their standard of care argument was, or defense rather, was she didn't have adequate signs and symptoms for any clinician to reasonably suspect a lower respiratory infection. You know, she didn't have a clinically significant fever. 99.9 is below the threshold of a fever. Some use 100, but most use 100.4, right? So she's, you know, a ways off from that. She had a normal respiratory rate. She had a normal oxygen saturation level. And a Z-Pak, they were trying to sell as a broad spectrum antibiotic, which it is, but that was a really prudent choice by the clinician because that covers the vast majority of bugs. You know, MRSA is exceptionally rare. And that's true. You know, they had they even had some literature about how rare MRSA is, but really how rare MRSA pneumonia is. When you look at all pneumonias, MRSA is not a very common cause of pneumonia. Our response to that, of course, was, we're not talking about every single patient who has pneumonia. We're talking about a patient who comes to you who said, I've been exposed to somebody with MRSA. But they also had an infectious disease expert who's, you know, a very well-credentialed, good witness, John Flaherty at Northwestern, come in and say that if you look at the records from her father's stay, her father who had MRSA pneumonia, that one, there's a question if he really had pneumonia or if he just had a MRSA infection and some respiratory illness because he was much older and compromised. And two, they more likely than not didn't have the same MRSA infection, that it was a freak, you know, occurrence, a crazy coincidence that they each had MRSA because of some of the labs that were done suggesting that he perhaps had a different strain. So, you know, they really did a good job of kind of pulling out or trying to pull us into the weeds, creating a lot of confusion and stuff in the infectious disease analysis. But ultimately, their theory was, so this was interesting. They had originally, it seemed during discovery, kind of defended the upper respiratory infection diagnosis, but said she didn't develop a pneumonia until sometime later, sometime before presentation And because of her risk factors, diabetes and a smoking history, she developed a very rapid infection. She basically had some compromise as a result of those things. And so it makes sense that at some point in the 48 hours between when she left this outpatient visit and presented to South Suburban that, that infection took hold, that pneumonia developed, and she had an explosive onset. Right? But an interesting thing they did at trial that I don't think ended up working out was that the clinician, the physician assistant, never mentioned influenza in her deposition. And so she just kept saying, yeah, I thought upper respiratory, and I thought it because of these signs and symptoms, and I thought it because of the normal respiratory rate, the lack of a fever, the normal oxygenation levels. But at trial, they came up with the idea that flu is an upper respiratory infection. And so really when she wrote upper respiratory infection, she was diagnosing flu. And the reason she chose not to treat it is because Tamiflu, the treatment for flu, should really be given in the first 48 hours after onset of symptoms. And this appointment occurred 5 days after the onset of symptoms. My response to that was, on day 5, you don't expect the flu to be getting worse. It should be resolving and or, mostly resolved. So the fact that she's coming into you on day 5 means that this bacterial process more likely than not has begun. Again, just kind of another common sense argument, but I, backed it up with expert testimony about, the development of a superimposed bacterial infection on a viral infection. And then what we ended up doing was my partner, Larry Rogers Jr., did the adverse exam of the physician assistant, which went very, very well. I did the open, and right away we called her, and he did a really brilliant exam of her. And he didn't necessarily challenge so much the lack of discussion of influenza in her deposition. But what defendants had done was, after discovery was completely closed, after my experts had been deposed and theirs had been deposed, they filed a supplement of her opinions, of the PA's opinions. And for the first time, they had all these explanations as to, how she really meant flu and so on. And we ended up saving that cross for their experts. And it came out really, really well that, she never mentioned flu in her deposition, right? You never, ever saw her say that. So I think they came off looking a bit disingenuous. I think that helped us highlight the fact that she didn't even diagnose flu. I mean, she really got nothing right. She spent only 8 minutes with her. She gave her a Z-Pack. A Z-Pack is something that probably most people on the jury had been given at some point for, a less severe illness. So we kind of built that up over time, and I thought it ended up coming in very, very well at trial.
Yeah, that's brilliant. I love that, because I know I had a trial once where a similar situation, the nurse ended up adding some new information to trial through a trial disclosure that went kind of unnoticed, and it changed a lot of the different elements. And we confronted her about it directly. And honestly, we talked to the jury afterwards, and they were like, I think you were kind of hard on this nurse. And I think doing it through an expert, I think makes a lot more sense. And staying on experts for a second, I know you talked about the defense had a very well-credentialed, well-qualified medical expert. Some auto cases, you get, these lower quality experts. Med mals, you usually get the best of the best on the defense side. How do you deal with someone who is, respected and credentialed, and they're testifying against you?
It's tough, right? And what always makes me nervous is that they're bringing in kind of these brand names, for lack of a better term. Like, everyone knows Northwestern is a top hospital, right? So and Dave Hall did a brilliant job of really building up this guy's credentials. They had Patrick Fahey, who maybe you've had on cases. He does a lot of testifying, but he was the head of Loyola's pulmonology and critical care ICU for a million years. So, they're building up these locally well-recognized, well-respected institutions. And so what we did was kind of one of the only things we felt we really could. One, I built up the credentials of our experts because they were very well credentialed. The, things that they actually had to call their infectious disease expert out of order, which at the time made me nervous because he was going in our case in chief, which I didn't like. But we then kind of got the final word several times over on causation. But I got to see how Dave Hall presented his credentials. And so I kind of mimicked some of that in my exam to say, And that's also an academic institution. That's also, so many 100 beds. That's also, I kind of just did that kind of stuff. But then the other thing that we really hammered was bias, that, yes, this is a locally well-recognized and respected institution, but you guys all know each other, right? I mean, Dr. Fahey, you've testified on numerous cases with Dr. Fahey. You've testified on behalf of clinicians at Advocate all the time, and clinicians at Advocate. Is that really right for you? Subtly making the argument, is it right for you to be the one giving opinions in this case? And the way we kind of addressed that in closing was like, we asked you guys all these questions to make sure that we would have a fair, unbiased jury. When we talk about the credentialing of the experts, they're all credentialed. But when we talk about if they're the right experts for this case, are they know each other? They've worked, and so we kind of just tried to say, look, we brought you people who didn't know anybody involved here, who are in the right areas of practice, who still come from impressive institutions with a ton of experience and, a relevant background, but they had no ties to any of the parties. They had, and that's what we did to try and deal with that.
No, I think that's great. I mean, because that's one of the harder parts about, most of our experts on the plaintiff side, we have to go out of state. So right. It's not institutions, unless they're, nationally renowned, aren't necessarily recognizable to the average juror. But, you say Northwestern, you say, University of Chicago, then, their ears perk up. Oh, that's right down the street. I know that. It's that's an interesting way to address that. I like that. You're talking about closing, so you have this case, you put in your evidence, and now it's time to talk about, converting, the harms and losses of your client, into trying to fix it to a dollar amount. How do you help the jury do that? The hardest task they have to do, assuming that they decide for you.
Yeah. Good question. It's so tough. We did do a lot of work trying to preface that in voir dire, which I think is very helpful. And interestingly, in this closing, and I've done this one other time with another one of my partners, but I ended up addressing liability. So I went first and I addressed liability. And then Larry actually came in and did damages. I thought that worked out well for a couple of reasons. But one, they don't have to then hear me drone on for 2 hours. But two, I thought liability in particular, that defense counsel might have a tougher time kind of attacking me personally as like a nice, honest, female litigator, as opposed to, someone who would probably be seen more as his peer, Larry, so that was a little strategic. But what we like to do, and like I said, I did this one other time where Tom Siracusa addressed liability and I then came in and did damages and close. And what we like to do is give ranges, kind of when we're suggesting values to the jury. We spend a lot of time talking about the losses, and we only kind of put out a number. We don't spend a ton of time justifying the number, but we just talk about the losses for a long, long period of time. Then we go down and put out numbers, but we almost always put out a range, because I guess the feeling is, or at least my feeling is, that you're emboldening the jury. You're not giving them an exact, dollar figure that is reasonable in your mind. You're giving them just a range, and again, we don't try to justify it. This is legitimate. It should be between this and this because, instead we just spend a lot of time covering the damages. And then we go through and make these suggestions that are inherently a little subjective because they include a range. So yeah, that's usually the approach that we take. And I think jurors like it. And then in rebuttal, we address the fact that Advocate didn't even take the time to give you any sorts of thoughts here. They dismissed the entire thing. So, just drawing again, another kind of juxtaposition between the approaches here, that they didn't even give you the credit or this case, the validity to make any counter suggestions,
What kinds of considerations, you talked about the different things that you go through with the jury. What kinds of things are you listing, particularly on the non-economic damages, and what kinds of considerations you have coming up with what you're ultimately asking of the jury?
Yeah, that's a good question. I guess every case is a little bit different in that regard. Here, we had some really lovely testimony about this woman who, didn't have a lot of money. We couldn't talk about that necessarily, but we talked about all of the sacrifices that she made for her family and her sons. And despite, having a lot on her plate, she was a single mom. who raised her kids, 3 boys, no less, while working at some points, multiple jobs to be able to give them the opportunity she wanted them to have. That even, despite all of that responsibility, that she made time to be there for all of them. She was there for the births of her grandchildren. She was there when her one son who served the Army, each time he was deployed, she was the last one that he saw before he boarded the plane. And so I think the idea that this woman was their biggest fan and supporter came through. So we reminded them of some of the testimony that her sons had given. And then we showed a bunch of family pictures to tie those stories to, and try and put a face to the basically medical record that they'd seen so often. So Larry did a beautiful job of showing those and then talking about, not everybody has that person who's always in your corner, constantly rooting for you, constantly being there to support you. One of the sons had said his mom was not only his mom, she was his best friend. So we just kind of pulled those pieces out of the earlier testimony, showed these photographs, and talked about how that love and that support and that guidance, all of the things that are really loss of society damages are priceless. And, interestingly, since our client, the decedent's husband, had passed away, we couldn't call him at trial. We didn't know he was going to pass away, so there was no evidence deposition. So we had his discovery deposition read in with only a few redactions of, some kind of irrelevant or prejudicial stuff. So I was real nervous at first that this wasn't, a clean, kind of polished exam the way I certainly nothing like what I would have done had he, been present. His losses would have been the biggest losses. And, they only existed for about 5 years before he passed away unexpectedly. So, but interestingly, and Larry did a beautiful job of this, I did ask a couple questions in this discovery deposition to elicit, some of the losses he had sustained. But interestingly, when opposing counsel was questioning him about something pretty benign, unrelated to his losses, he launched into a very long description of how hard it's been for him. And so Larry went back to that. Do you remember when he was asked this question that had nothing to do, he was asked a question about taking out the garbage. It was something, I can't remember. It was something very, it didn't have to do with his losses. And he just shared, he couldn't hold it back. He shared all of these things. That's how severe this loss was to him, that years later, when he's being asked this type of a question, he gives this type of it. So yeah, that's how we tried to pull it all together.
So after the closing, the jury goes out. I'm sure you're very relaxed, very calm, not at all nervous while that's happening. How long did you have to exist in that state? And then what was the ultimate breakdown of the verdict that you got back from them?
Yeah, good question. So I think the jury went out just after around 2:30 p.m. And our judge had us back at 5 and basically had the jury come in and asked them, are you anywhere near reaching a verdict? Otherwise, she was going to dismiss them for the evening. And they kind of looked around and said, yeah, I think we need 5 more minutes. And we were like, oh, great. So they left again. And, about 5 minutes later, came back in and read the verdict. And let's see, I think the loss of benefits to the husband and to the sons was about $600,000. The grief and sorrow for the husband was $1 million, and the same for the sons, another $1 million. And then the loss of society, $500,000 to the husband for those 5 years, and then $1.5 million to the sons, 3 sons for their loss of society. And then the pain and suffering and the emotional distress to the decedent were each $1.5 million. And really, she was unconscious that same day that after presenting to South Suburban Hospital. So we had proofs about her pain and her suffering from when she was discharged from Advocate, for those 48 hours, but they mostly came through her husband who had passed away. So we didn't, using his discovery deposition, we had certainly a lot of evidence of, her difficulty breathing, that she had trouble sleeping, that she had no appetite, that she just wasn't feeling well. But a lot of those proofs actually came in the emergency department record, showing 10 out of 10 chest pain, showing severe inability to breathe and those sorts of things. So, we had to do what we could with, I guess, the sources of proof that we had. And then, the other two, the economic damages were about $250,000 for the medical care and about $200,000 for loss of earnings.
It's a tremendous result. Absolutely tremendous result. And it sounded like you were able to talk with some of the jurors afterwards. What was that like, and what kind of feedback did you get?
I always like to, talk to the jury if we can and say thank you. So they ended up finishing, around, I'd say 5:30, 5:45. I could tell a lot of them kind of wanted to get home, but they were kind enough to stay and share just some, some basic feedback. And I always ask, is there anything I can do better? Is there anything that you could tell me, to improve my representation of clients like this? And they were very complimentary. Actually, interestingly, a couple were like, oh, I understood the medicine, right away. I didn't need the additional experts. And I was like, really, great. Wouldn't have guessed that. So in a way, that's good news to hear. I didn't get as much feedback as I think I would have if we had ended in the afternoon, before kind of dinner time. Just a lot of kind of, pleasant things. One person thanked me and Larry for doing this kind of work, for representing people who, suffer a wrong like this, because she realized that that's got to be really challenging, that, and she kind of went back to the medical record thing. I know you don't have documentation from your client. You don't have these things. So thank you for doing this and fighting for people like her. It's like, oh man, best nicest thing anyone said.
That's amazing. That's amazing. So what were you as a lawyer, what kinds of takeaways do you have from this whole experience and the result?
Oh, that's a great question. I think if ever you can use the medical record to your advantage in the way that we were able to do here, you do it. Because usually I feel like in cases, obviously we're relying on the record for a lot of things, but if there are certain statements or admissions in the record just that are beneficial to you, to just absolutely hammer that, from voir dire through opening, through out all your witnesses, but then to just kind of repeat these themes. One of the themes that I was trying to build up was listening to your patient, that it's essential to listen to your patient. She came into you telling you about this MRSA exposure and what was done for it. I mean, nothing, right? And so I think developing kind of common sense themes like that will really resonate with a jury, because probably most people have felt like they've gone to the doctor and weren't listened to, right? So building up kind of themes like that and doing it wherever you can throughout the course of a trial is really, really compelling and powerful. And those messages, those themes will absolutely be received.
That's absolutely tremendous advice. Again, I want to thank you so much for coming on and sharing your experience with us. I know I really appreciate it. I learned a lot, and I think anyone else who does this kind of work will certainly appreciate and have lots of takeaways from your experience. So thanks again.
Thanks so much, Matt. Thanks for having me.
And now we're back after our interview with Kate Conway. A great conversation. I learned a ton, a lot of, I'm inspired. I'm inspired to take on my next case and excited to get back in the courtroom. But before we wrap up today, we want to give you our 30-second trial tip. One thing we do to make our cases stronger and our trials better. John, what's yours for this week?
As I'm listening to Kate, and she's incredibly bright, and you can tell, but she, again, does such a good job educating. I'm just brought back to advice I received when I was a very young lawyer, and it's learn the medicine and learn it inside and out. You can't do this work. You can't try cases. You can't do complex work like Kate's doing unless you know that medicine inside and out. So just, it's difficult and it's complex. So take your time to really study it and really learn the medicine so that you can speak intelligently about it.
And that's kind of a perfect segue into mine for this week, which is simplify your case. And that can really only be done after you've done the work. Once you've done the work, you can figure out what are, relevant issues, but not necessary issues. And you can cut those out. Kate talked about how she told the jury, this is about a MRSA infection. And, that there was a lot of other aspects to it, obviously, but she came back to that at the end. This is still at the end of the day about a MRSA infection. And I think that's powerful. It's clear. It gets right to the point. And I think that's all something we should strive for, to be that that clear with the jury about what the case is about at the beginning and at the end. And that's our episode for today. I want to again thank Kay Conway for taking the time to talk with us and sharing her experience. Definitely a lot to learn from her for all of us. And remember that you can follow us and send us comments, questions, and episode ideas, or just troll us on Facebook, Instagram, and Twitter at On Trial Podcasts. Until next time, we'll see you on trial.